Hello, and thank you for joining us for the next session of the Destination IP Virtual Summit. In this session, a panel will discuss navigating patents through open source. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. Also, feel free to follow us on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to Eugene, Anup, Shebli, and François.
Thanks, Michelle. Welcome, everyone. Thanks for joining us today. Today's panel discussion on open source and patents. Today's panelists will provide us with several years of in-house and law firm experience dealing with open source and with patent issues as they intersect with open source. On today's panel, we have Eugene Kim, who is currently a principal counsel for IP at Twilio. And Eugene has 20 years of practicing IP law experience and has been managed patent departments at companies such as eBay, Zynga, Nimble Storage, and now at Twilio. And next we have François deVilliers, who is currently of counsel with Schwegman. Prior to Schwegman, he was chief IP counsel at Plantronics, and before that, he was director of IP at Creative Labs. He's also worked at several law firms in and outside of the US. His technical experience extends to various technologies, including wired and wireless telecommunications, RF transmission protocols, audio signal processing, computer hardware, software, and networking. Before entering the patent profession, François worked as an engineer in the inertial navigation field. A little about myself. My name is Anup Suresh. I'm currently a registered patent attorney with Schwegman, where my practice mainly focuses on electrical software and computer technologies, patent procurement and development of patent strategies. Prior to Schwegman, I was in-house patent counsel at Hewlett-Packard and Hewlett-Packard Enterprises, where I managed multiple patent portfolios in software and server space. And before that, I was an IP attorney at Shepherd, Mullen, Richter, and Hampton. Prior to law, I was an embedded software engineer at Boeing and worked on avionics software. Co-moderating this panel with me is my colleague, Shebli Mikailli, who is a registered patent attorney with Schwegman. His practice focuses on preparation and prosecution of US and foreign patent applications and representing clients before the US Patent and Trademark Office. His technical expertise includes technologies in electronic, computer, and software arts. So before we get started with the discussion, I just wanted to give a brief overview of open source licenses to get, sort of set the context for our discussion. And we'll begin with what an open source license is. And although there's no set definition for what an open source license is, generally, at least in the context of software, an open source license grants a licensee permission to freely use, copy, modify, distribute software in source or binary form without license fee or royalty. They generally have no restriction on field of use, and they generally require that the licensee preserve legal notices within the code. Examples are GPL, BSD, Mozilla, MIT, and a few others. Quite a few others. In place of a formal definition, there is the open source definition, which is a set of 10 criteria that a license must conform to be considered open source by an organization known as the Open Source Initiative Institution, I think. The organization that defines and maintains the criteria for the OSD. It's interesting to note that the OSD does not include any criterion relating to patents, so no need for an open source license necessarily to include a patent provision to be considered open source license by the under OSD. Whether or no open source license raises issues for clients is usually based on whether it contains copyleft provisions and based on whether it contains patent license provisions. Within a license, a copyleft provision allows for the creation of derivative works by a licensee, but requires those works be made available under the same open source license as original work. Open source licenses are generally categorized as being strong copyleft, weak copyleft, or non-copyleft or permissive license. For strong copyleft, the copyleft applies to all distributed derivative works that fall under the license, whereas for weak copyleft is generally used in connection with licenses for software libraries and allows other software works to link to the licensed library and be redistributed without legal requirement for the software work to be redistributed under the library's copyleft license. And then of course there's non-copyleft, where there's no requirement that a derivative work or modifications be made available under the same open source license. Next, we turn to patent provisions. An open source license may have an express license or provision or have nothing at all. Where there is an express patent license, it can be broad, like in the GPL3, where there is an express patent license to all licensors' patent claims that are infringed by making, using, or selling the licensor's code. Or it can be narrow, like in Apache, where there's an express patent license to all licensors' patent claims that are infringed by the contribution alone or in combination with larger works or original work. And then finally, where the open source license is silent with respect to patent licensing, such as with BSD and MIT, this kind of creates a gray area patent coverage. For example, a license may have use or sell, a licensee may have the right to use or sell the technology, but not other patent rights. It also creates situations where implied patent license may exist based on licensor's behavior. So clearly, there's a lot of considerations to factor in when considering open source when it comes to patents. So with that brief overview, we will now turn to our panel, which will be discussing topics relating to things clients should consider with respect to open source, internal policies and procedures for open source, and some questions relating to open source and patents specifically. Please note that we may not get through all the questions or our entire agenda, but please feel free to ask questions through the Q&A and chat. And if it does not get answered during the discussion, we'll do our best to kind of follow up after the webinar. And with that, I'll turn it over to my colleague Shebli to get the discussion started.
Sorry, I was on mute there. Welcome everyone. So, in this first section, we're going to be kind of just going over general considerations regarding open source. So, I kind of want to start off with, asking both Eugene and François, what your general feelings are regarding using open source at a company. Do you find it to be something that has benefits, drawbacks, and however you want to address it? So, maybe Eugene, we can start with you.
Sure. I think the thing is I think really it's up to kind of like your business and engineering teams as far as their thoughts about using open source. And so I would say that open source, maybe about 15, 20 years ago wasn't as prevalent, and now it's just kind of everywhere. So definitely I would say the use is expanding. So, my role is basically, hey, if engineers want to open source things or use open source, then I really need to kind of like support their decision for that, and also kind of tell them about their risks, but then also tell them about what implications there might be for a patent portfolio. But from the engineer's point of view, for open source, I mean, they're sometimes familiar with certain open source components, and it's faster time to development as they're under time pressure to deliver certain code or certain products. It really shortens the time for development. And also there's no like ongoing royalty fees or ongoing license fees, so it's cheap. Some of the drawbacks are definitely, you need to consider some security risks, right? And then also make sure that you're complying with the licenses.
So did you want to add anything to that, or?
Yeah, sure. So my view of open source is that it's a resource like any other, and when deciding to use it or not, you do have to evaluate, as with any other resource. Does it make sense for you? In the early days of open source, there was a lot of fear that the open source obligations would infect your proprietary hardware, and the next thing you would be obliged to release your own proprietary software. And so back in the day, it was, you know, stay away from open source. But the reality is now that if you ignore this resource, then you can end up being at a competitive disadvantage compared to other people, other companies that are, you know, making sensible use of the open source resources that are available to them. You know, there is some of the benefits. You know, the initial development cost might be less, development cost and speed, but you know, you really are transferring that cost to a legal compliance. There are sort of downstream costs that take away some of the advantage of the original upstream costs. In terms of, I think most engineers now want to be able to use open source in some manner, and it's actually can potentially be you know, a recruiting tool if your company has a sensible policy around open source. Yeah, and
Yeah, I mean, it seems.
so. My take is neutral to it is a resource that can provide benefits and advantages.
Yeah, I mean, so it does seem like the engineers nowadays, you know, are using open source more, and that's something that's becoming of greater, you know, importance to them. So that's something you found in your experience too, and like you're touching on, it's a recruiting tool. Have you noticed something similar, Eugene, that, you know, having, if you want to keep talent, especially in the Bay Area, you know, you kind of have to participate in these programs?
Yeah, I think it depends on which type of engineers they are. And I think that there's certain areas that have a lot of open source, let's say like, you know, data center software or something like that. And, you know, so I do think like, you know, whether you're kind of like pro open source or not, I don't think is a deciding factor for your company, but it's definitely, I would say, a factor for people who are pro open source. And so I would say that there is a fraction of people who it's really important for them to work at a company that's pro open source.
Okay. So it's, I mean, you guys somewhat kind of answered what my next question was going to be, was just, you know, then what are your general feelings on how to approach use of open source, you know, whether you think you take a hard line approach with, you know, whether it be to always use it or not use it, or, you know, try to provide some sort of balanced approach. But sounds like, you know, you're both recognizing that there's some benefit in using open source. Do you want to talk a little bit about your approaches, or an approach that you would recommend to others?
Well, for me,
go ahead, François.
I think the main thing is to have a mindful approach to open source, so that you think carefully about how to approach it, how to use it, how to participate, how to meet your obligations, and also, you know, depending on the company, if you're a startup company, it might be very tempting to immerse yourself in open source, but then you have to think ahead to, well, what is this going to look like when a larger company, a larger, more conservative company comes along and wants to acquire us, right? We don't want to give them a thorny nest of open source problems. So it's, I guess, a mindful approach is the approach to have. Assess it objectively and make careful decisions and have procedures in place to make sure that you're meeting your obligations.
Yeah, I would echo that. I definitely agree upon a mindful approach. I think, you know, collaboration, I think, is key as far as, you know, working with the engineer who's working on open source and trying to understand what their business goals are, and kind of like working together to come to a solution. Now, if you feel like there's a certain issue, whether it's a copyleft issue or there's a, material patent in your portfolio that may be effective, then you might have to say, the hard no there, but you kind of want to pick your battles a little bit.
Mm-hmm.
And I think the other thing too is making sure that that person understands the implication for the company. They might just be like, oh, I'm just working on this big one project, but it could have effects, it could have ripple effects kind of on other teams, and then making sure that you have the proper approval as well in your procedures for making sure that, a junior engineer says, hey, I want to open source this, but it's really valuable IP, and making sure that, there's some type of VP of engineering or CTO blessing for that approval.
Yeah, okay. I think that's a real good segue into our next slide here, which is kind of getting more into what you guys do as far as putting a open source policy in place. Anup, are you going to talk about this, or did you want me to continue here?
No, you can go ahead and continue with.
Okay,
Yeah.
great. So I mean, you kind of already touched on some of the things. Do you think it's important then, I guess, to have a designated open source policy in place? And if so, what are some of the reasons to do so? I mean, you kind of touched on some of these in your previous answers, but maybe kind of talk about that loosely, and we can kind of get a little bit more specifics about some of the things that you might be doing to perhaps, educate engineers or promote it within, or, draw distinctions between open source and patents. Or
Sure, I'll take this. I think, yes, it's definitely, important and worthwhile to have an open source policy in place, not only for usage, but for contribution as well. Just kind of making sure that, sometimes policies can be very long, and just making sure that it's kind of like easily digestible. I think that you want to definitely discuss, on the use side, kind of some of the making sure that you're complying with the open source terms for attribution notices. But then also determine whether, you have any copyleft risks. And I think this goes to the point of understanding what your business is. I think a big thing that you need to consider is, hey, are you distributing any open source code? And so if you're distributing open source code, then, and you have a copyleft license, and you mix your proprietary code with your open source code with open source license, and then you distribute it, then that's going to really trigger some of the copyleft effects. So, when there are M&A acquisitions, I mean, you aren't familiar with that technology, like something that you're going to have to determine in a shortened due diligence period is, hey, do they distribute code? Like, how much of their code, are they a SaaS company, or are they more of a device company and their software sits on a device? And understanding that risk, I think, would help kind of dictate, what your policies are, and also, how frequently you would do an audit too.
yeah, to do that, as far as assessing your risk, do you have, like, perhaps did you consider the types of licenses that you're willing to work with? I mean, do you have certain that you are kind of off the table, or will you consider all of them under certain circumstances, or there's some factors maybe you consider?
I think you typically green light your permissive licenses like MIT or BSD. There's a whole range of them, like the beer license, where you have to buy a guy a beer if you ever run into them. So, most of the permissive licenses you can just green light. Some of the ones that you really want to be careful are the copyleft ones, like GPL. Even Affero doesn't necessarily require distributions, and it may have a copyleft effect. You want to be mindful of that. So, then there's licenses like LGPL, or kind of like in the middle. But you don't necessarily want to just completely greenlight it, but you want to make sure you're doing some vetting of it.
Francois, do you have anything to add to that, or?
Yeah, sure. I think that my view is it's critical to have a policy, but as Eugene says, it needs to be accessible and understandable. And a good way of defining the policy is to have a matrix or a flow chart with different use scenarios to say, based on the risk, and to say, what is the kind of use? If it's internal use, then quite possibly there might be no negative implications from the use of open source, because you're not distributing it. If have decisions based on, as Eugene said, based on which type of license it is. If it's a permissive license, this is the level of permission that you need to get. And then, of course, as the licenses get more and more risky, then the amount of review and the level of authority needs to increase accordingly. And on the patent side, that's of course, if your proprietary technology might find its way into an open source release, you need to consider that very carefully. Look at the implications of patent licenses and the implied licenses for the open source licenses that don't have an express patent license. There's a strong argument there for an implied patent license, because you're releasing this code to the world with an authorization that people can, make, use, sell, modify, redistribute. And it's going to be a really tough argument if you try and sue someone for using the open source code in the manner that you have released it. So in some ways, the implied licenses are a little tougher, because scope is less defined. Anyhow, got a little bit off topic there.
No, not at all. So when you have like an engineer, right? Let's say that comes to you and wants to either use some open source or participate in a project in open source. What kind of recommendation would you give to somebody, as far as what they should do as far as steps, like, to provide an answer to that? I mean, is it a good idea to have some sort of checklist that you go through based on different licenses? Is it a good idea to create some sort of documentation as far as where it's being used? And if so, what kind of information would you include in that documentation?
I think it depends on, you can have a form, but also you can have a form, and the question is will the engineer fill it out? And so, I think that's kind of your policy may dictate like what you want when you want the form to be filled out. Probably on the contribution side, you would want to make sure that they do fill out a form. Some of it is just hey, if you make a contribution, will it be to an existing open source project, or are you creating a new one? What is the general functionality of what your project is? Also asking whether there's any third-party licenses, whether it's commercial open source. That will dictate whether you can open source, and if you do open source, which license you can use, right? Typically, if it's permissive licenses, then you should be fine. And then, as far as the naming, like you kind of want to make sure you do some type of just minimum check for some of the naming rights, because here you're kind of like doing a very noble thing and open sourcing something, but then somebody's unhappy with your name and you get sued for trademark infringement. So that's a risk. Yeah, I would definitely, encourage forms, but I don't think that you want to overburden some of your engineers with having them unnecessarily fill out forms.
Yeah, I think it really depends on a sort of holistic approach is good, and it depends on a number of factors. You know, what is the open source code being used for? If it's a driver for a Bluetooth interface or something that's you know, fairly minor and far from your proprietary application, you're obviously going to spend a lot less time on it than if it's a you know, system of a set of APIs or something that you want to use that's going to be much closer to your proprietary software. And then there are you know, related factors like how well supported is this, or how broad is the use of this this open source that you want to use. If it's been around for a number of years, it's used by lots of companies and has you know, many contributors, and there have been no problems with enforcement actions, then you can say, well, that's a check in favor of that of use of that code. So it really is kind of you have to look at all of the considerations, but hopefully, depending on, you know, minor usage with a permissive license, then you don't want to overburden your engineers, as Eugene says, with a huge due diligence project.
I mean, to that end of not, you know, overburdening them, do you recommend that, you know, somebody or, you know, an attorney handle the documentation themselves, or do they perform any verification as to what the engineers might provide them as far as information of which license there are, and where it is in the software?
Yeah, I don't know if you want to overburden the attorneys in filling out forms. But you know, it depends on what tools that you have at your disposal too. So you know, some companies license open source scanners and audit software like Black Duck or Flexera, which is the old Palamita. I think they rebranded to another name. So sometimes those tools can help with you know, identifying what components you have. But even that is burdensome as well too, because you just, you know, you scan it, but then you have to kind of go through the report and go through and figure out all the false positives too.
Mm-hmm.
And that is burdensome as well. And so, yeah, I would say it's a mix. Definitely, I think, you know, educating your engineers on open source and open source risks is definitely helpful, either through some type of presentation or maybe on your wiki site. But also, you know, open source touches a lot of aspects of IP law as well. So in order to understand the effects of open source, you have to understand copyrights, and you have to understand patents and possibly trademarks too. So, you know, when you do educate your engineers, you're going to have to touch on and educate them on other aspects of IP as well.
François, anything or?
Well, I think that I don't think it's unreasonable to expect the engineers to do a little bit of work here, because by its very nature, open source is going to save them some time. I don't think the form is necessarily overly burdensome. As Eugene said, there are tools that you can use to scan. There are even some freely available tools that will scan for license terms in a code repository and then generate a report from that. And so I think, you know, the engineers should participate in some way rather than just throw it over the wall and expect the attorneys to deal with it. It's also I also feel it's good when new employees come in as part of the intake process, if you're a code-heavy company, to have some kind of initial primer to say, well, this is our basic approach to open source, and here are the procedures, and we can talk to you if you want, because someone could easily come across from another company and with their open source philosophy, and then the next thing you know, you're about to release a product and it's full of open source. So education is key as well.
Okay. Yes, I mean, I think that kind of brings me into something else I was going to ask about. But so one last thing about this, documenting, where the open source is being used, or what things are involved in open source is obviously important, just as attorneys move, or, people coming in and out, for the company to maintain a log. But like you're saying, you want to kind of balance out with the burden on people. What types of information do you think is key to include in any documentation that you might create?
Well, I think that the use to which the open source will be put compared to the company's business, how it relates and interacts with your proprietary software, how it's going to be distributed. There are some cases where with is it going to be statically linked or dynamically linked, and the obligations can differ depending on how you provide your code and the open source code to the world if you're distributing it. And then some of the other factors I've mentioned as well, such as how long has this been used, how many people use it, and there are some sort of special cases. So for a Linux operating system, if all your application is doing is using the published interfaces for the Linux operating system, that's generally accepted as not going to pull your application into open source obligations. But if you start having delving into the operating system yourself to do custom calls and things, then that's again a different scenario. So it's again a kind of holistic approach.
Anything, Eugene, or?
No, I don't think I have anything to add there.
All right, so maybe let's talk a little bit about the types of things you might want to discuss with engineers as far as educating them on open source. Like what might be some important things to point out to them that can help them understand that, hey, maybe we can open source some things but not all things, or how much of a benefit do you think that provides to getting that type of education when you do have to say no?
Like I said before, you want to give a overview of IP. You want to, like Anup did before, you kind of want to give an overview of open source. And your education is not just limited to engineers. You could be educating people in the corporate development team, or commercial counsel, or people who don't have a good understanding of technology too. So I remember I gave one presentation, and then at the end, it was to like fellow attorneys. Somebody was like, "What is source code?" Right? So just kind of making sure that you cover some of the basics of, hey, what's the difference between source code and object code, right? And I think we understand as patent attorneys the differences between the two, but not everybody understands that. Definitely, I think you want to talk about the different categories of licenses, permissive licenses, weak copy left, and talk about those risks involved, talk about the implications to the patent portfolio. So they might be working on their one project, but how do they know whether something is whether we have a patent on it? And so just kind of educating them on kind of the whole process, and then kind of making sure that you have just the tech tech approval or the business approval at the appropriate level, and the legal approval too.
And I think that as far as the education goes, just to let them know what the general philosophy of the company is as far as open source, and then stress that it is kind of a fact specific inquiry. And engineers really like concrete examples, so that if you can, as part of your presentation, you can say, okay, here's an example of how we used open source in this case, and here's an example of when we said no, and here's an example when it kind of blew up in our face, or here's an example even with some of the enforcement campaigns. Here is where people have got sued, so watch out for that. Also just from approach it from a kind of value perspective, in terms of, okay, we're going to be participating in the society. Let's participate in a manner that is not going to make the society annoyed with us, as a kind of global principle. There are some people who say it's not that much of a big deal. You do your attribution and you provide your source code, and nobody's going to hassle you. So try and be a good member of the community, and that will point you in the right direction for many things.
So I guess finally, as far as just having a open source program, do you guys recommend maybe providing any recognition for participating in open source? Not so much using the open source, but if you're working on if an engineer is working on a project that is being open source.
Probably not. It's not like a patent incentives compensation. I wouldn't do anything like that. I do think that if there's a bigger project that is going to be favorable to the industry that you are open sourcing, then you may want to call that out. But I probably wouldn't do any type of, I don't think I've ever heard of anyone really do any type of incentive program related to open source. That being said, too, it's going back to the collaborative approach. Certain companies have open source program offices or open source program managers, and that typically they're not within legal. They're in more the tech or the platform or operations team. So just working with them as far as kind of making sure that they're also the eyes and ears, and they're involved with the education of your employees about open source.
I think as far as open sourcing your own software, you really need to think carefully about the why, and not to have over optimistic expectations that, gee, we're going to release this code and thousands of people are going to work on improving it, and it's going to provide safe but easy access to our systems for our developers, and it's some of that might be true, but it's not a foregone conclusion that all of the good things you are hoping for when you open source your own software are actually going to become a reality. And then you also need to think about, well, what are my long-term obligations? If I open source this and lose interest in a couple of years' time, is it going to look bad that I've done that? Are people going to be annoyed that I'm not doing upgrades or patches or maintaining the repository? Right?
Interesting. All right, we actually got a couple of questions here, so I'm just going to interject those real quick. So one question is, what are some of the biggest misperceptions you've encountered about open source?
Misperceptions, I think it depends upon who it is. I would say most non-technical people will not really understand open source, and that's a good kind of like a lot of attorneys who don't understand open source. Probably from the tech side or the engineers is one of the biggest misperception is, hey, what's your implication on your patent portfolio, right? And I don't think people really appreciate, they just think about their code, their project, right? And it's just like, hey, I want to open source this, but you know, just asking them saying, hey, you know, is there, you know, anything patentable either within your contribution, and then you have to also evaluate whether anything in your patent relates to this project, and you're basically providing a royalty-free license. And so if you do that, and you're, let's say you're in litigation with that patent that might be affected, it really hurts your patent litigation case, because it just, you know, you're offering your, you know, your damages model, you're just saying, hey, you know, you might be, you know, let's say in litigation, you're seeking a certain, you know, percentage of royalty, but meanwhile, on the other hand, you've offered this software on a royalty-free basis that would hurt your damages case.
So you're saying the extent of the impact of using some open source, that might be the misconception, right? People
Yeah,
realize.
yeah, and the other thing too is, depending on your role, it's like certain people may not have the company view that you have. They certainly don't have the view of your portfolio that you have too, but they also don't have kind of like, you know, maybe they just work kind of like within their business unit and not with other business units too. So just making sure that they understand, you know, that impact as well.
Yeah, and that's where the education really kind of comes into, I think. François, do you have anything to add to that question?
Yeah, sure. I mean, I agree completely with everything that Eugene says. You know, some of the misconceptions are that it really is this virus that is going to infect your code and is to be avoided. And you know, more that's a lot of people have that old kind of view of open source, as opposed to it's a reality, wide adoption, and can provide significant advantages if it's used mindfully. The other sort of more minor misconception is, you know, the one of the acronyms is FOSS, free and open source software, and when people hear that free, they think that it means that there's no money associated with it, whereas it's more, the software is free. It's like freedom of expression. You're setting the software free. It's not like free as in free beer.
Mm-hmm.
So it's just the philosophy of the free. It's more like freedom of speech than you're giving something for free.
I would agree with that too. I think people do get, you know, open source software confused with, let's say, public domain software, right? And they just think like, oh, I open source this and I kind of like dedicate this and this is the public domain. But I think, you know, there's kind of like when people specifically, you know, dedicate to public domain, there's not necessarily a license. They just have some type of statement saying, oh, I dedicate this to the public domain. But still, with open source software, you might license it under MIT, but you still are the copyright owner, and then you can choose to license under a different license.
Mm-hmm. All right. So my last question here, I guess, is, you know, what do you do when, I mean, I wrote, what do you do when something goes wrong? But what I kind of mean is, one, what do you do when someone's used some open source license or some open source software that you hadn't approved or you didn't know about? And then also, you know, what if you kind of change direction? What if you've used some open source some open source software, and you kind of want to make that software proprietary? What are some things you might do?
Well, I think in terms of it's really, again, it's going to be a factual inquiry. If someone has taken a huge a bunch of you know, copyleft code and put it into your you know, core technology, you're going to probably want to recode that. You know, and as far as if you want to make something proprietary again, you can't pull that back. I mean, it's going to be out in the world, but there's nothing to I believe you're talking about when you open source your software, that there's nothing to stop you, as Eugene said, from releasing a proprietary version. I mean, you're the owner of the copyright and the technology. There's nothing to prevent you from saying, well, in the future, being mindful of any code that we might have. If it's all our proprietary code, we're going to, release future versions as proprietary versions.
Eugene, anything or?
No, I don't think I have anything to add there.
And in terms of if the company is caught having violated the terms of an open source license and then is facing down a lawsuit, one option is to take a paid license from the copyright owner, that's always an option.
I would agree with Francois. It's definitely, some type of factual investigation. And, you've got to do kind of some initial assessment or triage. And then you might have to call, outside counsel too, who are open source experts. And you'd be like, hey, what do you think about, for whether code is statically linked or dynamically linked, and kind of the real effects on the copyleft. So you do your internal investigation, but then you can also just ask for help as well.
Okay. All right. So I think that's it for this section here. We move on to the next portion. I'll pass it back to you, Anup.
Yeah, thanks. Just quickly, it looks like we got another question. Can you comment on the issue of patent trolls in the open source arena? In particular, this person submitted the question is an end user, not a developer, and has received troll claims on open source software that they're allegedly using. Eugene, François, either one of you?
Yeah, I would say that patent trolls will look everywhere. Yeah, I think one is, if you are the end user, did you put in that open source software, or is this an open source software from one of your vendors, right? And is there some type of indemnity provision that you may want to trigger to have your vendor step in and defend the lawsuit? But there's other options as far as patent strategy organizations like Unified Patents, where Unified Patents goes out and files IPRs and tries to invalidate patents for certain areas. That's an option. There's Open Invention Network as well, who does a lot of, kind of like, I would say, defensive services for the Linux environment as well. And so those are some options too. But, that's the thing is, you decided to use open source software, and there's some risks involved. And some of the risks are you could get sued by a patent troll. And if you just take it, part of the open source license is like, hey, there's no warranty and there's no liability. So you're not really going to go after kind of the person who provided the open source, but you have to pretty much, assume that risk.
Okay, thanks. François, anything to add?
Yeah, I agree with that completely. If you've acquired the open source yourself directly from GitHub or wherever it is, then there's clearly no warranty there. But if you're an end user of a package that someone else has assembled to provide to you, then hopefully there's some reps and warranties and indemnities that you can go back to them. And unfortunately, the thing with open source is that anyone can take a look at it. So the patent trolls can study its all the ins and outs, as opposed to your your compiled code that you might release yourself, that patent trolls are not going to be able to look into that easily.
Okay, thanks. Hopefully that answers the question. So with the last few minutes that we have left, just wanted to quickly go over some more questions specifically relating to open source and patents, and maybe some of this is kind of overlap with questions you guys may have answered already. So specifically, do you feel there are situations where it'd be beneficial to have both patents and open source being used together with respect to a technology? Start with you, Eugene, if you can.
Yeah, I think one of the decisions is, let's say you write some code and you have patentable subject matter, but the plans are to open source the code. So then your decision is like, oh, if I'm going to open source it, I'm going to offer a royalty-free license. My patent rights are diminished, and should I even file for this patent? There might be certain cases where you still want to, depending on what your patent strategy is as far as being offensive or defensive, you may want to, even though you've offered royalty-free license, you might want to seek an injunction. It might be tough to get since you're already offering a royalty-free license, but it would be something that you could consider. So yeah, I think that they can exist together. And the other thing too is that certain companies have dual licensing models as well, and so maybe they're going to fork open source software, or they're going to dual license with a proprietary license and a open source license too. And so certain versions might be under an open source license, but then you make a decision like, hey, I want to have a proprietary license, right? And so then what you can do is for your future versions, you can have a proprietary license and try to generate revenue that way. And there it's like, in that situation too, it might be good to have some patents that kind of protect your proprietary software.
Okay, thanks. François?
Well, for me, it's they can coexist, but it really gets down to the question of why. Why am I going to open source my code? And think very carefully about that. And hopefully you can only you can open source a piece of the code that will be to your advantage for it to be out in the world without that including your core technology. So they can, but I'm a little more skeptical of the benefits of releasing code as open source than using it yourself, mindfully, of course.
Yeah, some of the some of the open source licenses that you have to have like this defensive termination of patent rights as well. So, you license your, let's say you say, okay, I'm going to offer a royalty-free license, patent license, but then let's say somebody sues me, and then, in defense of in patent litigation, then you can terminate the license, right? So somebody, let's say, is using your open source software, but then kind of like turns around and sues you for patent infringement, you could terminate those rights.
Okay. So next, what do you consider when using both open source and patents with respect to technology? So effectively, how do you decide, say you've decided that you are going to patent something that you're going to open source, how do you decide which portions to open source and which to sort of cover with the patent? And I know François kind of noted the why, so that's one factor, but how would you go about deciding that?
François, you want to take this one?
Well, it just again gets kind of back to a factual inquiry for me, and you know, being a patent attorney and protecting IP, I tend to want to keep everything close, be more protective of the intellectual property. But you know, there may well be circumstances that releasing something of open source might make sense. For example, you know, one strategy, say if you want to make modifications to say Linux, if you want to add some extra, you know, features to an open source operating system, or use some unique calls that are going to the depths of the kernel, you probably don't want to write that into your own applications, because that might implicate the copyleft aspects of that. So one thing to do is to think about, well, is there a layer of abstraction I can put in there? Can I create an API that's with hooks that can call the things that I need to do, that I need called, and then I release the API so that when I write into the open source community, so that when when my application needs that functionality, I'm calling my own open source API that other people can use as well, to provide a gap between your core technology and the modifications you need to make to the open source software.
All right, great. And I appreciate the specific example. So in situations where there is a decision to go forward with open sourcing something that's also being covered with the patent application or patent, what licenses would each of you would prefer in these situations? Maybe specific ones.
Yeah, I think a lot of companies use MIT, BSD, or Apache as though the permissive licenses. But it's not just a legal decision. It's a business decision as well, as to, you know, hey, what is your expectation of the community that you're trying to target with this open source project, right? And so if it's Apache community, they're expecting under Apache 2.0, right? And so there might be a kind of like a certain group of developers who have a related project and they're all under MIT. So you might want to think about using MIT. So it's not just a legal decision, but it's also a business one.
Okay, François?
Yeah, I second that. And also if you want it to be more widely adopted, you're probably going to want to use one of the permissive ones, because the more you ratchet it up to the the strong copyleft ones, the less people are going to want to touch it.
Okay, and I see we only have a few more minutes, so really quickly, would you see a situation where it makes sense to use a license or sort of release that product under a strong copyleft license?
You might be, let's say you derived your code from a copyleft code under the copyleft license. You might be required to do that. Also, it might depend on the community, again, that you're trying to reach. So if the community is all, you know, GPL favored community, then you might want to consider it as well.
Okay, François?
I don't have anything to add.
Nothing. Okay. Well, that concludes our panel discussion portion. If the audience had any more questions they wanted to ask, feel free to do so, but I think we only have about a minute. So if there are no other questions, then I thank the panelists for joining and taking their time to kind of share their experience. And thank you to the audience for taking the time to join us today. Just stay safe and healthy.
Yeah. Thanks. Anup, you
All right,
too.
thanks everyone.
Well, thank you guys.
Bye-bye.
Bye.
Good luck.